Friends, to understand Section 27, we have to also understand that Section 27 has provided for certain exceptions, which clearly state that certain kinds of restraints on trade is permissible. Um of course, we know that none of the right to trade or freedom of trade is going to be absolute. Even the Constitution of India does say that any kind of freedom of trade, occupation, and business is to have reasonable restrictions on the ground of public order, morality, so on and so forth. Similarly, the Indian Contract Act states very clearly that in case of sale of goodwill, there can be a restraint of trade. The classic case on this is the case of Nordenfelt versus Maxim Nordenfelt Guns and Ammunition Company. It's a case of 1894, uh, and it probably explains the rule of exception under Section 27. What does this mean is, if you have sold your business, you can be imposed with a reasonable restraint of trade not to carry out a similar trade or establish a competing trade because you have sold the business, but also you have sold the goodwill of the business. This is necessary to protect the interest of the new buyer, because what will happen is the buyer will buy the business and also take over the goodwill, and later on you will go ahead and actually establish a competing business of your own. Then the whole purpose of buying the business gets defeated. So whenever businesses are bought and sold, that includes not only the sale of tangible businesses but also the sale of goodwill, then in those circumstances a non-compete clause can be held to be very much valid, and that is what the law prescribes under Section 27 of saying these are exceptions in which restraint of trade is definitely acceptable. So you will notice that when you talk about the Nordenfelt case, this guy was a gun manufacturer. He decided to sell his business. His name and his business name were one and the same. They were very popular. They were bought over by another entity, and later on, he decided that he need not adhere to the non-compete clause, which the court said, is not something that can be accepted. But again, in the Nordenfelt case, you will notice that the courts have said that even if we, for an instance, agree that a non-compete clause is necessary, it falls within the exception because there was already be a sale of goodwill, and under Section 27, such restraint is permissible. The courts have said that, look, the non-compete clause also ought to be reasonable. Which clearly means that, say, non-compete, where shouldn't Nordenfelt do? So he should not enter into the gun ammunition business. Okay, that is the space of the business. Two, he must not do so in a particular locality. And three, for a reasonable period of time, say 5 years or 10 years, but it cannot be 25 years, right? So the time, space, locality rule also becomes an important critical element to test whether, even if the non-compete clause has been held to be enforceable, the reasonability of it will be tested by the courts of law to allow the exception of restraint and permit such agreements to be enforceable at law. You will also notice, friends, that there are statutes that also agree that restraint of trade is necessary. And hence, one of the statutes is the Trade Union Act. Now, when you look at the Trade Union Act, you are a member of a trade union. If you are a member of a trade union, probably you cannot associate yourself with any other trade union, society or trade union movement. These kinds of restraints are something that the Trade Union Act actually permits. So an agreement in which a trade union member is restrained from joining some other trade union is considered to be reasonable and permissible as per the Trade Union Act. Right? So the Trade Union Act says it would not be considered in restraint of trade because that is necessary to protect collective bargaining. It is necessary to protect the spirit of the fact that someone else will try to break the union, break the people and the laborers being together. People will actually try and poach, instigate, influence unduly, and that would actually defeat the purpose of trade union movement. And hence, if there is a clause that restricts members from taking membership in other unions, such kind of restriction is reasonable and will not attack Section 27. Similarly, under the Partnership Act, friends, any kind of restraint can be imposed on an outgoing partner, a partner who is retiring. We call him the outgoing partner. So the Partnership Act says an outgoing partner can be restrained from carrying on a similar business to that of the partnership firm. Obvious, isn't it? That you have two partners. The third partner is going out, and if he decides to establish a competing business to the existing one, then this partnership will go down. And hence, to protect the interest of the partnership, and any outgoing partner can be imposed with restrictions, and those kinds of restraints are considered necessary and reasonable. They would not in any way attract Section 27 to hold the contract or the agreement to be void. That is how you will notice that the issue on restraint of marriage or restraint of trade is not an absolute kind of rule, and exceptions are necessary and created. And we'll have to say which restraint is absolutely necessary, because some of the restraints, as I said, is necessary for the employer, some of the restraints are necessary for the buyer, some of the restraints are necessary for existing partners. And in the spirit of the trade union movement, these restraints are considered. So, in terms of subjectivity, you will notice that the courts can actually deal with cases on, say, a case-to-case basis to judge whether that restraint is necessary or that restraint is unreasonable, and how does Section 27 come into place, especially in holding these agreements to be void. Finally, I also have to reiterate this fact that in all of these cases, especially in the Nordenfelt case, the courts did exercise the blue pencil rule. The blue pencil rule is, as I told you earlier, is a rule of an editor who tries to strike out whatever is unreasonable. Right? So the agreement can be allowed to be valid, provided some of these objectionable terms, years, conditions is removed by using a blue pencil rule. So it is the editor's choice. Hence, the judges can exercise those choices and say that this term is in restraint of trade. Rest of the agreement or the contract can be held to be enforceable. Right? Moving forward, friends, there is one more section of a lot of interest to all of us, and that section is the section 28. This is the section which says that agreement and restraint of legal proceedings are also void. Section 28 is of a lot of significance because it says that approaching legal proceeding happens to be a matter of fundamental legal right to every citizen. Contracts and agreements cannot restrict such a right of access to legal proceedings. So legal proceedings is a matter of public law. It's a matter of constitutional choice. It's necessary to protect your interest and your rights against infringement. And hence agreements cannot say, look, in case of breach of contract, you cannot go to the court. Right? You can't expect an employer to stop an employee from approaching to the court. If there is any such clause which stops the rights of employees or any other contracting party from approaching to the court, from exercising their legal rights and legal proceedings, including the remedies that are there for breach of contract, then those kinds of clauses or agreements can be held to be against Section 28 or attracting Section 28, and hence the agreements shall be void. Interestingly, one of the clauses that has been evaluated is called the Ouster clause. Now, in the United States, this is quite a common practice, and hence you will notice that different jurisdictions deal with the restraint of legal proceedings differently. Now, in the United States, there is this clause called the Ouster clause. What does this clause look like? It looks like this. It states that neither of the parties shall have the right to approach to the court of law. Rather, the courts cannot exercise jurisdiction over this contract. That is what an Ouster clause means, which means you take away the jurisdiction of the courts. You do not want the courts to decide this matter, and both the parties actually agree that this is so. Now, in the United States, I think where freedom of contract is kind of absolutely respected, if the parties are not in an unequal bargaining position, it's not a consumer-related contract. It is a B2B contract. The United States courts have actually said Ouster clause is fine. Look, it's like this. If the parties intend that the contract is to be binding, then the contract is binding. If they intend that it should not be binding, the contract is not binding. So the intention of the parties is very relevant for the contract to be made enforceable. Similarly, if an intention is expressed in the contract that the courts must not exercise any jurisdiction, then the courts will not exercise that jurisdiction, because that is what the intention of the parties is. So why should courts, forcefully exercise jurisdiction over contracts? Because in the United States, they believe that the contract is part of private law, and private parties can determine whether to subject it to the court jurisdiction or court remedies, or whether they would want to seek other forms of remedies. So the courts are not going to exercise forceful jurisdiction. So in some of the states, this kind of a clause was held to be valid in the US, and hence from there, I think this issue on ouster clause came into place. Now, in India, friends, please note, any kind of an ouster clause will be considered as in restraint of legal proceedings. Because in India, Section 28 very clearly does not allow parties the freedom to remove the jurisdiction of the courts. The courts have inherent jurisdiction to try matters relating to contracts. This is possible due to law and the kind of legal system that we have adopted. Freedom of contract in India is definitely not absolute. It is not something supreme that shall be respected. The courts will exercise jurisdiction and hold such ouster clauses as directly contravening Section 28, and this would definitely amount to making an agreement or attempting to restrain the exercise of legal proceedings by the court of law. So ouster clauses are definitely not acceptable in India. Second, the choice of law clause. Now, one of the interesting facets that we have to understand in modern day contracts is that parties generally decide which law will apply to this contract. Now, what we do is we exercise our freedom of choice and freedom of contract. Now, choice of law. Now, this is interesting, friends. Now, when we say that the Indian Contract Act 1872 applies to the territories of India and it extends to the territory of India, what does that mean? It means that it is the default law, right? Whenever you make a contract in the territory of India between two Indians, inevitably, you don't have to choose any law, because the default law is the Indian Contract Act 1872, right? That will definitely apply. And similarly, the Specific Relief Act of 1963 is the law that is going to be applicable for all kinds of contracts. Having said this, friends, where does the choice of law kind of a clause come into place? It may come into place when one of the parties to the contract is not in India or is not an Indian, or the subject matter of the contract is to be executed beyond the territories of India. Now, when you make international contracts, that is what I mean, one party being non-Indian or the contract being executed beyond the territories of India, we may want to call such kinds of contract as international contract. Now, in international contract, there are two choices. Please note, choice number one, you can choose Indian law because one of the parties is India. Two, you can choose foreign law because another party is from that land. Or you can choose a neutral country law as well. That is also another possibility, isn't it? Correct. Now, these are three different possibilities that can exist. And hence, in such kinds of international contracts, the parties have the freedom to choose the law, right? They can choose either of these countries' law as being made applicable to the contract. So choice of law is a possibility and an option in certain kinds of agreements and contracts. But the real question is, would it amount to restraint of legal proceeding? Friends, please note the Indian courts or the Indian legal proceedings will only apply Indian law. They will not apply any other country's law. So your choice of law will depend upon where the contract will be finally adjudicated in terms of legal proceedings. So Indian courts or Indian legal proceedings are not going to apply or interpret foreign law or foreign contract law. They cannot exercise that kind of jurisdiction because the courts in India only apply the Indian law, right? Prima facie. Unless it is based on certain kinds of an appeal in terms of interpretation of the rights of the parties based on foreign law, which has substantive issue of law to be determined even in India, the courts in India will not actually deal with those matters as well, right? So, choice of law directly does not attract Section 28. The parties have the freedom to do so, And in certain cases, this is applicable, as I told you, is a choice that we can exercise inevitably for the kind of contracts that have been made. And choosing a law becomes inevitable in international contracts and is very much valid as well. Finally, on this point, what you have to know, friends, is restraint of legal proceedings, right? The term restraint under Section 28, there are two forms of restraint that one needs to analyze and understand. The courts under Section 28 have said if the restraint is absolute, right, giving you no choice whatsoever, then it will attract Section 28 and it will be held to be void. But if the restraint is partial, right, which is just minimal or partial, then depending upon its necessity and reasonability, such kinds of restraint are permissible. That is something that is possibility as well. Interesting part of modern day contract, be it government or private, is choosing the forum for adjudication of disputes. This is also called in popular contract management programs as the choice of forum clause. Now, interestingly, friends, law and forum are a choice that the parties can exercise in certain kinds of contracts. And as I told you earlier, it becomes inevitable in those kinds of contracts to choose because of the nature of the contracting parties and the contract that is being made. Now, choosing the forum can be something like this, friends. For the convenience of the parties, especially if we say, can I give you an example here, like the Life Insurance Corporation of India. When Life Insurance Corporation of India makes a contract, they probably have offices all across the country. And when they make all of these contracts, they may want it to choose one city court as the forum for adjudication of disputes. Say, they would say something like this, that the City Civil Court of Mumbai shall have jurisdiction to try all disputes arising from this contract. And this will be uniform across all Life Insurance Corporation of India contracts. Now, what are the advantages of choosing a forum? Please note, you're not saying that the courts will not have, but you're just saying the Mumbai court should have the jurisdiction to try disputes arising from this contract. Now, can you exercise such a choice of selecting one city and its court to exercise disputes arising from the contract? The primary answer to that question is yes, you can. However, there are some challenges, and those challenges arise from the Civil Procedure Code and various other legislations, which by default give the jurisdiction of the dispute to courts in which those disputes arise. For example, let's take immovable property disputes. If there is dispute of immovable property, friends, you will notice that wherever the immovable property is situated, the courts in that jurisdiction can only exercise jurisdiction over those kinds of disputes, right? Because the property is situated there and the courts have the primary jurisdiction, so it cannot go to anywhere else. So I think one has to be careful in trying to understand the legal implications of the choice of forum clause. And we can always say that it is available for movable property. It is definitely available for international contract. Now, why international contract? Now, international contract is simply because, friends, forum, like an Indian is making contract with an American or with a French company or a French national or with some entity in France. See, the parties have three kind of forums to choose from. The parties may say, look, because the goods are being sent to India, let the Indian courts exercise jurisdiction, right? The parties probably have the freedom of choice. It's a B2B contract. They want to exercise fair bargain and the freedom, as we would want to call it. The point is, friends, look, no French national would accept the jurisdiction of the Indian courts because for them it's going to be inconvenient. If suppose the dispute arises, the French national or the company has to appoint lawyers in India. The French nationals don't know the Indian contract law, the Indian legal system, the interpretations, what is the requirement, what are the documentations, how to lead evidence. So these are difficulties that the French companies are definitely going to be very, very cautious about. So they are not going to easily accept that the courts in India should have jurisdiction. Similarly, I think it's definitely not comfortable for an Indian to accept the French courts for the simple reason, I would say, that France is still a civil law country and we are a common law country. So why should an Indian I don't think if he is, if he's guided very well with legal advice, will choose the French courts to have jurisdiction to try the disputes arising from this contract. Remember, the courts can either exercise jurisdiction based on the nationality of the parties, because if you're a national of India, the Indian courts can also exercise disputes, or it can arise or exercise jurisdiction based on where the cause of action has arisen or where the breach has arisen. If the breach has occurred in India, the courts in India will have jurisdiction, right? If the breach has occurred in Mumbai, the Mumbai courts will have jurisdiction. That's how, the courts exercise the matter of jurisdiction, or wherever the immobile property is situated, the courts over there will exercise that kind of a jurisdiction. So this is something that people will have to appreciate, that yes, the choice of forum is available, but in what kind of contracts can you exercise the choice of forum? Because remember, friends, if there are two Indian parties, right, and the subject matter of the dispute is in India, and the parties decide to choose law and forum outside India, I think to a larger extent, this can be a contract against public policy. Let me repeat. If the parties are Indians, both the parties are Indians, and the subject matter of the contract is definitely arising from India, so is the cause of action arising from India. If the parties decide to choose a law and a forum beyond India or outside India, that kind of agreement can be opposed to public policy. Why can it be opposed to public policy? Why it is opposed to Section 23 as read with Section 28 as well? Because you are ousting the jurisdiction of the courts in India by seriously taking into consideration a law and a forum outside India. That means you are literally using some kind of an ouster clause, right? So I think that's something that parties must be careful about. There is a very interesting case of the TDM Infrastructure Limited case, where the Supreme Court definitely made this observation that, a over-exercise of these kinds of powers of choosing law and forum outside India will not be considered in favor of public policy, right? Now, choosing the forum, friends, has always been a tricky affair, because sometimes the French national and the Indian national may say, look, let's not go to either of the countries, let's go to a neutral country. Now, neutral country courts, proper court as the case may be, the matter of fact is you cannot exercise rights as a court unless you have the right to apply the law. So courts of every jurisdiction can apply the law of that land alone. So you cannot go to Switzerland and say, please apply the Indian contract law or the French national contract law. So that's definitely not possible. So choosing the forum has to be done in extremely wise manner. You have to study the nature of the contract and the parties. You have to know the legal system of which the forum belongs to, and whether such kind of vesting of jurisdiction. This is called the vesting of jurisdiction. The parties vest the jurisdiction to one particular country or one particular court. Whether such kind of vesting by private parties, please note, this is not a public law. This is not about state as parties to a contract. This is about private contract. Whether that kind of vesting of jurisdiction is something that the courts of that country can exercise in the very first place. If they cannot, then you will know the problem, right? The problem is then the French national will go to his court, the Indian has to go to his court, because obviously to whom you are vested is unwilling to exercise the jurisdiction for adjudication of dispute. So then it will be probably considered as a poorly drafted contract, and that's, I think, is definitely not something that is acceptable. One other matter is something that is an exception to Section 28, and that's arbitration. Friends, if you decide to go to arbitration in your contract, that will not be considered as an agreement in restraint of legal proceeding. So arbitration clauses are very common, they're very acceptable. It is an alternate dispute forum. Parties can go to arbitration, after which, if they have still some kind of an issue under law, they can still probably take it to the courts of law. So arbitration is like a legal proceeding, is what the law says and what the courts have already decided. It's a very, very formal process of dispute resolution. It is outside the court. It is by a panel of arbitrators. It could be one arbitrator, it could be 3, it could be 5. We know that the law says it has to be odd numbers. It cannot be even numbers. So you can't have 2 and 4 arbitrators. Now, friends, arbitration has certain distinct advantages, while it has disadvantages as well. We'll come to that a little later. And why today in modern day contracts you have an arbitration clause? Friends, the simple reason to have arbitration is that, look, contractual disputes are disputes about business, right? Unfortunately, when you go to the court for seeking remedy, or when you take proper legal recourse, it's quite time consuming. So the average time probably in the Indian court for any commercial disputes ranges anywhere between 2 years to 4 years in the trial stage itself. Now, that's pretty longer time for businesses to lose the opportunity of business, the opportunity to make profits and money, and be accountable to their stakeholders, including shareholders. So it's not an option to vest all commercial disputes to legal proceedings, including the fact that even now, if you wish to do it to the commercial courts, because we have the Commercial Courts Act, and we expect most of the commercial disputes to be actually assigned to the commercial courts as well. So the problem is the courts are already burdened with the number of matters and number of cases, and commercial disputes can actually add to the burden of pending cases before the judiciary, and hence arbitration is a viable alternate option. Now, arbitration has already existed in this country, right from 1940. Right now, we have a 1996 Arbitration Act, which has been amended from time to time. But we say it is the Arbitration and Conciliation Act. So conciliation is another forum, arbitration is another forum. Now, arbitration, friends, when you look at it, the other advantage is that, look, courts usually have all matters to decide on a particular day. They cannot probably exclusively give time for a particular matter, right? It's based on the priority of the subject matter and the how old the case is. The courts will actually give it some preference. Now, in arbitration, because the arbitration panel has been constituted only for this contract and this dispute, they will give more time to that kind of a dispute, and there is a possibility that the disputes may be resolved faster and sooner than what a court could actually normally do. Now, interestingly, friends, the possibility is you can also get a specialized arbitrator, which means, look, commercial or contractual disputes, friends, are not necessarily disputes that arise from the interpretation of law or the application or reading of the law. So they are not necessarily legal disputes in the actual sense of the term. So commercial or business disputes can be, say, construction related. It could be engineering related. It could be design related. It could be financial related. It could be, related in terms of how the breach has occurred. So it could involve intellectual. So, there are so many kinds of challenges that arise in contracts. And every kind of disputes cannot be just decided by a lawyer or with a law background. So arbitration gives you an option of having the specialized person itself as the arbitrator. For example, in the natural gas kind of dispute that arose between Government of India and Reliance, it was about the pricing of natural gas. Now, on the pricing of natural gas, you will notice you need actually an expert arbitrator who has actually worked in natural gas sector to exactly tell you what kind of price it can be sold, considering the extraction, exploration costs, and then a percentage of profit that needs to be kept for the company as well. Those are classic cases where arbitration is very, very useful because the experts decide, it reduces the time, and you have actually someone who expertly resolves that matter, and hence the award that is given by arbitration has more respectability between the parties because it comes from someone who is specialized in that particular area. Of course, arbitration doesn't require advocates. That's a rule, but most of the arbitrations are conducted by the advocates itself, because the most of the process in arbitration is almost like a court system. Though it's not necessarily the proper judiciary, but the processes are almost like what the courts normally follow. What are the disadvantages of arbitration? Just quickly, I think there are numerous disadvantages. Then one is that right now, luckily, thanks to the recent amendments, arbitration has to be completed within 12 months. But that was not the case earlier. Unfortunately, it dragged on for 3 years to 6 years. And a lot of people felt arbitration is not succeeding in this country. But I think the recent amendments have helped that, you have to complete the arbitration within 12 months. You can extend it by some more time with the consent of the parties. Otherwise, that kind of arbitration fails. So time now is the essence of arbitration. That's one good point. Second, you will notice that the cost of arbitration was increasing because the number of sittings, the number of years was going high. So people lost hope in this. Again, now you will notice that while the law says that the cost of arbitration should be borne by both the parties, right now we have come across change of arbitrators whenever they have actually charged unreasonable fee. Interestingly, today arbitration is done through institutional arbitrations. It's not done ad hoc. Ad hoc means, I and you choose one arbitrator, but then you have the Indian Council of Arbitration. It's an institution, so you probably want them to have constituted the arbitration panel. Their fees is already notified, it is fixed, and hence the cost of arbitration can be reduced if you actually go to institutional arbitrations. So arbitration is still one of the favorite clauses that is drafted in a contract. We say in case of any dispute that arises in relation to this contract, or any differences that arise in relation to this contract, it shall be referred to a sole arbitrator being appointed by both the parties. Interestingly, in arbitration, the courts can also be involved for appointment of an arbitrator. That is under Section 11. You will notice that the high courts. So if the parties cannot agree who the arbitrator is, the courts can actually help the parties and appoint the arbitrator as well. Now, arbitration clause is definitely valid. It is an exception, and it will not be considered as an restraint of trade. And suppose there is an arbitration clause in an agreement, please note, at no point of time the courts can intervene in this contract. It would be the duty of the court to refer the matter back to arbitration or refer the matter to arbitration in case such a clause exists, and the courts cannot exercise prima facie jurisdiction whenever such clauses are present in a contract. So the courts have to show restraint, and this is a viable approach to resolve disputes in an alternate forum in a more efficient manner, and hence the law now very clearly helps resolution of commercial disputes in a faster and more meaningful manner. Finally, friends, when we look at Section 27, a few exceptions have now been incorporated into Section 27. There are some of the rare amendments that have been brought, amendments or additions, as you want to call it, into the Indian Contract Act, where the challenge of prescriptive clauses was brought into place. Now, prescriptive clauses, friends, are some kind of clauses that actually look at time to exercise the legal proceeding. That's how prescriptive clauses are looked into. So it's quite challenging how the restraint of legal proceeding really operates. Friends, your right to go to the court is definitely there within 3 years. That's the normal limitation duration for general contracts. It can vary on the special contracts. For example, in government contracts, the limitation time is 30 years. So 3 years is the normal time. So let's take the 3-year example. So 3 years from when? 3 years from the time the cause of action or the breach has arisen, parties have the right to go to the court. If they do not go to the court, then the Limitation Act very clearly prohibits you from seeking legal recourse. And the courts will say, sorry, you are beyond the time, and hence we will not entertain your suit. That's how the Limitation Act of 1963 applies to what we call as the doctrine of latches. Doctrine of latches means the doctrine of delay, friends. If anyone delays in exercises of the right, then God help him, the courts will not entertain the suits, because there ought to be some reasonable time that has to be fixed for parties to exercise their rights to go to the court and file cases and suits. It cannot be an unlimited time. That would actually result in a lot of public legal system disorder. So the limitation law has to be adhered to. And even in the Consumer Protection Act, we know that the time a consumer has to go to a consumer forum for any kind of defect in goods or deficiency in service is 2 years from the time he comes to know that such a defect or deficiency has occurred. So even consumer forums are bound by the limitation law, which it has been prescribed in their own legislation called the Consumer Protection Act of 2019. Now, one of the exception over there is, yes, this 3-year and 2-year rule can be condoned, and the condonation of delay means if you go beyond 3 years or 2 years, the condonation of delay rule may be pleaded before the court of law. It's a discretion of the court, and in certain circumstances, you will notice that the courts have said, okay, it's fine, we will condone the delay because we find there is a genuine reason why that delay has occurred. And one of the genuine reasons could be that the petitioner has suffered some mental, kind of an injury, he has undergone some physical health related issue, and hence he could not exercise the filing of the suit within those 3 years. And hence, in those extraordinary circumstances, condonation of delay may be permitted by the court of law. How does the prescriptive clause work? Friends, the point is, if this is the time that you have to go to the court, the 3 years or the 2 years rule that the law has prescribed, can in a contract we reduce this time of 3 and 2 years? So if the statute gives you 3 years time to file a suit, if the consumer protection law gives you 2 years to file a suit, can the contract say, look, if you don't file a suit within 1 year, your rights in this contract will be extinguished? The answer is, friends, no, you cannot do that. That will clearly violate Section 28 because it restrains your right to legal proceeding. Rather, instead of the word restraint, it reduces the time during which you can exercise your right of legal proceeding, and that would definitely attract Section 28. So if the law makes a higher prescription, your contract cannot reduce that kind of a prescription. So it is against public policy, right? However, prescriptive clauses can work in another direction where they say, look, it's not about fixing of the time to go to the court, but it is trying to fix a time wherein you notify the other party that you have a claim. You can still go to the court within 3 years, but you have to notify that you have an existing claim against me within, say, 2 months or 3 months. See, generally in insurance contracts, this is a common clause. The insurance contracts very clearly say, after you're met with an accident and you're claiming motor vehicle insurance, or after you wish to claim health insurance, within 2 months or 3 months, the contract can say something like this, that you must submit your claim. After you have been discharged from a hospital, you must make a claim within 3 months, or else your right over that insurance will be not there, it will be extinguished. This is the prescription of time between the parties. They actually say, please notify the claim within 3 months, otherwise you will lose the right to claim. You can still go to the court and challenge it. That's a different issue. But you have to know. Now, insurance companies, friends, would want to justify this. Why? Because, see, I have been admitted to a hospital. I got discharged today. Now, within 3 months, if I don't make a claim, the hospitals will actually probably not have the records. The insurance company will not be able to verify your claim and the records, and will not be able to evaluate whether your claim is genuine to the extent of what has to be reimbursed. The insurance companies will not be able to do their functions or contractual duties efficiently. So to bring about efficiency in the contract, I think some of these clauses can exist, right? So if an employee has any claim over the employer, say due to some injury at a workplace, he must make this claim within 3 months. If not, his right to the claim will be extinguished, right? So such kind of clauses, friends, are permissible. They are not considered in restraint of legal proceeding. However, you will again notice that the time that is fixed, and unfortunately, again in the insurance case, the insurance company unilaterally or one-sidedly has the right to impose that 3 months or 6 months or 1 month prescription, is it? That also can be tested on the ground of public policy, saying is whether it is reasonable or not. Like in the insurance case, I'm sure IRDA, that the insurance regulator, can determine the same as well. The courts need not intervene. So while the time that is prescribed to notify the rights between the parties ought to be reasonable, such kind of a time does not attract Section 28 and will not be considered in restraint of legal proceedings. Right? For example, we can always say something like that. Suppose you have been imposed with some kind of a sanction for the breach of the code of ethics of cricketers. And if the cricketer wishes to challenge the same, he should do so within the next 2 days. Right? This kind of prescription generally exists within organizations so as to bring about efficiency of concluding of such kinds of interdisciplinary issues within an organization. It is also brought about to bring about closures as soon as possible and not keep it pending for a long duration of time. So efficiency of administration is definitely something that the courts will not intervene. I think contracts can definitely have such kind of prescriptions, and if they're reasonable, they're always something that can be enforced as well.